Hello, everyone, and welcome to today's NeoSystems CMMC Town Hall. Now I'd like to introduce your host, Ed Bassett from NeoSystems. Ed?
Thank you, Don, and welcome everyone to our continuing series of Town Hall Ask Me Anything sessions on cybersecurity maturity model certification and related topics. My guest today, Robert Metzger. I do want to mention at the start that we are recording these sessions as part of our community outreach to the Defense Industrial Base. Our focus at NeoSystems as a managed service provider is on organizations that are seeking certification under CMMC. That's mostly who we have in our audience today. If you're in the audience and you have some questions for Bob Metzger, please send those in on the Q&A feature within Zoom, and I'll try to work those into the conversation as best I can. I'll start with introduction of Bob Metzger. Bob heads up the DC office of Rogers Joseph O'Donnell PC, a litigation boutique specializing in government contracting. He advises leading companies in aerospace and defense and information technology on matters including litigation, contract award controversies, national security matters, and regulatory compliance. Bob is the co-author of the MITRE Deliver Uncompromised report released in 2018. That was one of the initial sparks leading to the CMMC program we have today. Bob was also served on the Defense Science Board Task Force that produced the 2017 Cyber Supply Chain Report. So certainly well informed on regulatory issues around the cybersecurity space. Regular visitor here. I think you were last joined us in May. We've had a lot of interesting developments since then, Bob. So I'm glad to have you back and look forward to talking with you.
Well, thanks. Back in May, we were kind of at the start of the quiet period, which seemed to last forever, where we knew that DoD was doing an assessment of CMMC, and we knew that things would change. Well, it's only been about a month now since CMMC 2.0 was announced. So we know a lot more, but there's so many questions that we still have to get answered.
Well, in addition to the CMMC 2.0 news, we in October, Department of Justice announced a civil cyber fraud initiative, which ties into this certainly in the sense of being an enforcement around some of those requirements. So maybe I'll start with a question about that. This looks like the civil cyber fraud initiative looks like an enforcement action by DOJ aimed at pursuing companies that are not following cybersecurity standards specifically. Part of this seems to be about encouraging incident reporting. Part of it is about having the right defenses in place and maybe going after those that don't. We've seen some whistleblower cases already reporting non-compliant companies. What's the news here from DOJ? Like it's not a new law per se, right? This is just new enforcement.
No. Now, the False Claims Act has been around for I think more than 100 years, and DOJ has made many campaigns that have focused on many industries. Healthcare has gotten the most attention recently. But now DOJ has said through this announcement by the Deputy Attorney General Lisa Monaco on October 6th, they've said they're going to make civil cyber fraud enforcement a priority. And I think they mean it. I think they're looking to hire some more lawyers to help with this. What DOJ is saying is that the president has said that it's a national priority to improve cybersecurity, and that applies to both government as well as industry. And one of the tools that's available to the government is enforcement. And one of the most effective enforcement tools is the use of the False Claims Act to motivate companies to do a better job at compliance and, if appropriate, to sanction companies who fail to do it. Now, there's a difference between announcing the campaign and effectuating it. My present read is that the Department of Justice is serious in that it's looking for more cyber cases to pursue. It's serious in wanting to encourage whistleblowers to come forward to help bring those cases. But I don't think the Department of Justice today kind of understands a great deal about the complexities or nuances of the cyber compliance world that we live in. Their objectives are ones that we all would support. I'm looking at the announcement: build broad resiliency, hold contractors and grantees to their commitments, make timely disclosure of cyber events, ensure that companies follow the rules, and that's all great. But if you are accused of a false claims, you're looking at a highly disruptive and expensive investigation requiring hiring people like me and other consultants. It is a blunt instrument that can cause a lot of distress to companies if they are wrongly accused. And if they are rightly accused, it can generate a lot of liability. So if I distill all of this, I would offer the following comments. It's more important now than it was before this campaign started to be sure that you are thinking about not just compliance with cyber obligations, but the ability to document that compliance. You have to have evidence of the decisions you've made, the actions that you're taking. You don't want to try to justify something after the fact. It's also important internally to listen to dissenters. You know, the way an effective false claim allegation is made sometimes is if you have someone who is a CISO in the technical side, or even a consultant who proposes one course of action that the company decides not to take. Well, if there are situations where there are arguments about what is right, what is sufficient, and what isn't, if the dissenter is ignored and he or she has very strong feelings, well, that's the kind of person who can become a whistleblower. So what I'm telling my clients is, to listen carefully, to make sure that, every effort is made to convince the dissenter. If necessary, bring in a third-party expert to look at the issue and to evaluate the question and the answer. And this kind of problem comes up very often, Ed, because I think your experience will be that if you have 110 requirements, with the assessments that are supposed to be done by that 171A guide, well, there are very few of these requirements where there's just a single answer that's obvious to everyone. Some of the requirements can generate choices, which can range from, the benign, simple to do, rely on policies, to the extraordinary, to the expensive and highly disruptive. It could change an enterprise's operation. And so in the real world, there can be tough decisions where there is disagreement internally, even with experts.
I mean, taking aside the case where somebody really is defrauding the government intentionally, right? So they maybe should get whistleblown and should get caught. But for companies that want to do the right thing and are intending to do the right thing, what are some scenarios where they might find themselves running afoul of this and, having a whistleblower and having all the expense and hassle of trying to defend that? What are some of those scenarios where they feel like they're doing the right thing, but they don't, right? So and you're right, there's not always a single answer. They may say, yeah, we feel like we're compliant, but someone else may feel differently and may blow the whistle based on that feeling.
Well, there are a couple, right? I mean, one was spoken to yesterday by John Ellis, who runs the DIPCAC assessment group at DCMA. He said that if companies essentially falsify the policies and plans that they purport to rely upon, if companies misrepresent in their submission to SIPRs their score, if they put in a projected date to close all gaps, if DIPCAP comes to do a high-level assessment at your facility, John Ellis said that they're going to know within minutes that you don't follow your policy, that your self-assessment was wrong, that your score was incorrect. And so one way to get into a lot of trouble is to misrepresent where you are, what you've accomplished, what you plan to do just in that SIPR submission. That'd be a problem. Another way in which you can be subject to scrutiny, of course, is if you are the unfortunate victim of a cyber event. I mean, suppose that some event happens, and in the real world, it's often that you don't know when the event happened. It may be an APT and residing in your system for a time before it's effectuated. And you may not even discover that there's been a loss of information for some number of days after it's occurred. And even when you know that some information has been lost, you may not know which information has been lost or to whom or what they are going to do with it or whether anything will be done with it. Now let's call that the obscure case. The evident case is where you're subject to a ransomware attack. Information is both stolen and access is denied to your systems. Well, in either situation, if you have valuable controlled technical information and there really could be injury to the department or its mission holders, and you do make an incident report, there are ways in which an investigation could follow. The government could decide that you took too long to make that report. They could consider that it was willful neglect of your duties or even deliberate disregard for your responsibilities to make a late incident report. That could become the basis of a false claims allegation. They also may come and look at your systems. And suppose that there is a breach event that is highly impactful to DoD and there's some frustration or irritation about the timeliness and sufficiency of your disclosure. But suppose also that they find out that the reason that the attack occurred was because of certain weaknesses in particular systems, policies, or processes. Well, if they then look at your system security plan, if they then look at what you submitted to SIPRs, if they then look at what you purported you would do if you were subject to a DIPCAP assessment, if they find that you weren't doing those things, that you essentially were saying that you do the right thing but ignored those responsibilities, well then you could be the subject of a government investigation, and that investigation could result in a False Claims Act complaint.
So Bob, we got an audience question. The audience member asks, are you saying that they, I guess meaning the government, are you saying that they could come at any time and audit your self-assessment? Is that part of the rule? How likely is that to happen? And would they need probable cause? So there's a lot of parts to that.
Well,
I think more related, I guess, to CMMC and DFARS rules than the DOJ initiative, I guess. But
so everybody has a couple of contract clauses that count, irrespective of CMMC 2.0. We have the 7012 clause, which is the one that requires adequate security using the practices of SB 800 171. We also have the 7019 and 7020 clauses. And those are the ones that require you to have a system security plan, to perform a self-assessment, and to make those submissions to SIPRs of your score and your plan of act, or the date when you will finish closing the gaps indicated by your plan of action. Well, as I recall, in the 7019 and 7020 clauses, you agree that DCMA has a right to come to perform an assessment, a medium level assessment, which is somewhat cursory, just looking at your papers, or a high assessment, which is more intensive. Moreover, if the government has, it's a good question. I mean, DCMA certainly has a right to come and perform an assessment, and it's been made clear by John Ellis many times that they have the means, they have the people who are expert, and they can and they will do it. Now, if there's genuine suspicion of criminal conduct or fraudulent conduct on the civil side, there's a couple things that could happen. If there's a whistleblower, then that whistleblower might be taking documents out of the company and might be providing them as evidence to a whistleblower, private counsel, or directly to the Department of Justice. It's also possible that the complaint could be made to the Inspector General. That could be made by, there could be a referral from a program office to the Inspector General. Contractor X had my stuff, didn't protect it, now the Chinese have it, I want you to look. Well, the Inspector General could get a civil investigative demand or otherwise request or require information from you. These are not criminal cases ordinarily. A civil cyber fraud case is something where the government has a long list of investigative tools. At the most extreme, they could convene a grand jury and conduct a parallel civil and criminal fraud investigation. And in such events, they have the ability to use grand jury subpoenas and to even come to your facility unannounced and search and seize things. Now, have these things happened in a cyber case? No. But I've been at this for quite a long time, despite my youthful appearance. And earlier in my career, I did represent tier 1 companies in False Claims Act actions, defense contractors, where they were essentially looking at product substitution, deficient product pricing errors and the like. And I have seen situations of criminal investigative demands, grand jury subpoenas, and the like. These can be essentially what's going to happen now is that the DOJ's attention to the defense industry is going to focus on cyber. And frankly, Ed, I think they're going to be hoping to pull out of the woodwork whistleblowers, because they'll understand the problem and they may have evidence. DOJ doesn't really understand much right now. And they're going to be looking for the really bad case, as you suggest, the evidence of really bad intent, bad conduct, bad results, bad intent, willful actions. And they're going to want to make examples. And so if they find a case that, potentially could support pursuing the litigation in the court, well, they're going to do it. They're going to look for some bigger companies, and they're also likely to look for some middle-sized companies. And even smaller companies could find themselves, looking at a complaint filed by a whistleblower who is represented by counsel. Whistleblowers, if the government doesn't join a case and a whistleblower proceeds, they're called a relator in a qui tam action, and they'll be represented by private counsel. And they can pursue the case even if the Department of Justice doesn't join. And if they happen to win, as occurs with some frequency, Well, the whistleblower can get a pretty large share, I think up to 1/3 of the amount that's recovered in the case. So, is this going to change everything for everybody? Absolutely not. Is this something that really threatens the actions of companies that do the right thing all the time? Definitely not. Is this something that you can mitigate by being thoughtful, careful, compliant, and documenting your actions? Well, yes, you can reduce your risk substantially. But it's a new condition of government. Let's not call it surveillance. It's a new condition of potential government enforcement that should be considered when you make those close decisions on governance, risk, and compliance.
Let me push on that a little bit for security officers, compliance officers, IT people who maybe don't want to get mixed up in this, right? How does this initiative change how they should take on their day-to-day responsibilities? Should they be thinking differently, acting differently?
That's a great question. Now, some of it depends on kind of what you are. I mean, if you're a very small business, governance, risk, and compliance may be in one person. That may be, in an officer, and there may be a single technical person, if any. But let's assume that you're a middle size or a larger company. Well, if you have a situation that emerges where there is genuine question about what is legally required or not, or where you are concerned that a whistleblower already may be present, or that you may have a violation that you should disclose voluntarily. An important point: a voluntary disclosure can do a great deal to protect you against a False Claims Act case. Well, in that situation, we need to recognize there are a number of parties that participate. There could be a chief risk officer who's worried about governance, risk, and compliance. There will be a CISO or a CTO. There may be a CIO. Well, one of the things to recognize is that these decisions that have potential implications under the False Claims Act should never be made just by the CISO or the CTO, because there are issues of enterprise risk that are involved. It should be elevated to the C-suite so that they understand it. In-house counsel should be involved. If there's an in-house compliance specialist, they should definitely be informed. And if there are issues of law that have to be decided, these shouldn't be decided by the contracting person, by the CISO, by the CTO. This is where you need to bring in the lawyers. Let the lawyers decide the legal things. Now, although I am a lawyer, I certainly recognize and support the importance of getting as much done as you can without lawyers. We tend to add expense and process. But if you are in that gray zone where there could be exposure under the False Claims Act, well, you want to ask your in-house lawyer at the very least to participate. They must be informed. And in really difficult situations, it's smart to hire outside counsel. If you hire me or anyone else as outside counsel and we conduct an inquiry into the matter of concern, we can hire consultants or forensic people to look at it. Their work is likely to be privileged because they are experts hired by a counsel who is working under the attorney-client privilege. If you go off and hire the very same people to do the same work by yourself before counsel is involved, or without the involvement of counsel, well, it's all but a certainty that their reports, will not be protected against access to the government. And in a tough situation where you don't really know what happened, and you don't know who did it, if anyone, and you don't know what the consequence was, well, doing that internal investigation is a terrific idea. But if it comes up with really bad news, fraudulent activity, misleading conduct, well, if you've done that investigation other than under the auspices of counsel, it's just there as evidence that the government can get if they want it.
This is a kind of related audience question, and then I want to shift it over to CMMC 2.0 a little bit. They're asking about, you mentioned the 7012, the 7019, 7020 clauses as is what brings this to bear. Question is, does each contract have to be modified to include not just 7012, but also 7019 and 20, or does the Christian doctrine apply?
Interesting question. I mean, if you have an older contract that was issued to you, without the 7019 and 7020 clauses, there's the theory that you do not have to conform to newer clauses. The Christian doctrine generally tends to impose upon contracts those government terms and conditions which are ordinarily essential or imposed upon new contracts. I'm not 100% sure. I think the prudent course of action would be to assume that 19 and 20 do apply. by virtue of the Christian doctrine. The smarter move is always to do a little more in compliance and to avoid the risk. However, there's probably going to be at least a legal argument that could be made that 19 and 20 would not apply unless your contract is modified. I can't give particular legal advice here because I'd have to look at the details.
So the DOJ initiative, it does seem to be about mostly enforcement of current standards. CMMC is kind of heading that way as well with 2.0, right? It keeps the bar the same for FCI and CUI in terms of the controls that are required today. It's the same controls, maybe adding some on at the new level 3. In your mind, is enforcement the name of the game here? I mean, is that really where the DoD is at this point? And not just the DoD, but government in general, is rather than trying to raise the bar, let's raise the level of compliance with that bar. Is that how you see it more broadly?
I don't think so. I think
Okay.
Enforcement is just one of a variety of tools. And there are only so many lawyers in the Department of Justice. And even if there are more whistleblowers willing to go outside and try to make a case, if the Department of Justice doesn't join the case, then they have to convince the quitam counsel, the private counsel, that the case is good enough that it's going to be worth their investment over a period of years. So we're not going to see a deluge of cases. We'll see a few. We're not going to see a deluge of investigations. We'll see some. And again, for most companies, if you do the correct thing, if you act to comply with the requirements as you understand them and document your actions, you're going to be fine. Even if there are questions, the likelihood is that you will be able to answer them satisfactorily. I mean, the real situation that creates the most exposure is one that's actually being litigated in a case in federal court out in California called Marcus v. the Aerojet. This was a person who was either the CISO or close, and he strongly objected to the company's cyber course of action. And he concluded that there were many aspects of 171, the earlier 171, that were not being followed, and the company ignored his advice. Well, that's the situation where you have the whistleblower who knows a lot, who has the documents, and who feels that the company has deliberately disregarded the truth and taken actions contrary to what are required. Now, there's huge contention over the facts there, and the legal issues are numerous and complex. So compliance, what is this? Enforcement is just another means by which the government wants to encourage you to comply. But compliance has other sources. If you take a contract with 7012, you are essentially attesting that you're going to deliver adequate security in a dynamic environment using 171's controls. If you take a contract with 19 and 20, you have to go further by doing that self-assessment and reporting your score. You do not want to report a score of 85 if the real score you have is minus 22. You are going to have to put in when you think that the gaps in your compliance will be satisfied. If you put in February 2022, but you do absolutely nothing to achieve that, you create a little exposure. So, and the third reason that's most important to me, actually, other than enforcement and general compliance, is business prudence. In the real world out there, the reason that you want to protect yourself is not just because 7012 requires you to have adequate security and use 171. The real reason to protect yourself is that there is this broad array of threats who can go after your company and do enormous damage to you, even if they're completely indifferent to your being a defense contractor. There are all of the various forms of ransomware actors who may have no interest whatsoever in the fact that you're a defense prime or sub. They may care less about the substantive content of your information. They are only interested in money. And their criminal methods include not just denying you access to your system, but stealing all of your information. And they may well threaten to give it to competitors or to expose it publicly. I've represented companies, advised companies that are living with just this problem. And so what I would say to anyone is that, sure, 7012 is a reason to be secure. But if you just look outside and read the newspapers every day, read the technical services, you're going to see that any institution of any kind doing almost anything can be subject to a wide variety of ransomware attacks. And frankly, you are foolish if you do not act to protect the integrity. You're foolish if you do not act to protect the confidentiality of your information, which is what DoD wants, but also the integrity of your information and your information systems and their availability. And availability means that you assume that you're going to have a ransomware attack. You take smart measures to offload and back up your information. on a regular, if not current basis, and you have high confidence that you could restore your operations and your information in a secure fashion very rapidly. So it's not just compliance, and it's not just enforcement. It's just good judgment. But I'm seeing increasing number of lawsuits that are brought against many companies, by persons whose information is compromised, by companies where their information is compromised when another company suffers a breach, and by shareholders who say that companies have lost brand value or lost share value because of their negligence or failure to fulfill cyber duties. There's a lot of people out there who can complain and create liability exposure other than DOJ or other than DOD, contractual actions. You need to be thinking about all the sources of threats and all the forms of liability.
Couldn't agree more. Just let me shift gears a little bit on CMMC news. So CMMC 2.0 was announced a few weeks ago. Just last week, the DoD released the actual standard for CMMC 2.0. No big surprises there, except we all have to renumber our compliance matrices. But they also put out a couple of scoping guides. They put out scoping guides for level 1 and level 2. These answer questions about segregation, how to evaluate service providers, cloud providers, managed service providers. From your perspective, any surprises there?
Lots. I mean, they do answer some questions and they are useful, but I can make a pretty good argument that they raise as many questions as they answer. I mean, there's some whole new concepts and they make a lot of sense, but we really haven't dealt with this before. So they now tell you that you have to look at several categories of assets as you anticipate assessment. Well, one is the controlled unclassified information assets. Got it, check. Those are assets that process or store or transmit CUI. And the next is security protection assets. Those are assets that provide security functions irrespective of whether or not these assets process, store, transmit CUI. And then there's something called contractor risk managed assets, and then there are specialized assets. Well, contractor risk managed assets are maybe things in your company's system that could have CUI, but where you have policies or procedures that are intended to prevent people from actually sharing the CUI with those systems. This is what helps you determine what are the assets within a complex organization that are going to be assessed and which are not. And a contractor risk managed asset is something that you would define and document, show in the architecture plan as something that is outside that assessment scope. There's going to be a lot of questions as to what that means. And then we have this whole new category, specialized assets. These things are really not going to be assessed at all. They are assets that may or may not process CUI. They include government property, IoT devices, operational technology. I mean, these are things where, frankly, I think tacitly DoD is admitting that there is some stuff which previously could have been within that giant potential scope of CMMC, where CMMC just doesn't fit, where 171 really never worked. And so they're saying, well, we're just going to take some of these things, IoT, government devices, and OT, and we're going to say that these are specialized assets that you don't have to assess. Still going to be a lot of questions, how do you do it? And then there's also some key questions about, enterprise service providers. If you're using cloud, what standards do they meet? If you use tools from third parties, if you use managed service providers, do they have to be CMMC approved in total or not? How is that done? I mean, how are tool providers supposed to comply with CMMC? I have some doubt whether it can be done or should be done.
Yeah, and they specifically call it the case where the tool provider does not have any CUI. So then how do they, as you say, how do they comply? What exactly do they have to do, given that when they draw their little scope boundary, there's no CUI, there's no CUI assets in there, right? So
yeah, it would be highly counterproductive. I mean, if this is interpreted to mean that any tool provider, no matter how great they are, FireEye, CrowdStrike, and the like, if this means that any tool provider has to be CMMC compliant to provide the tools to the thousands of companies in the DIB who use them, it's ill-advised. It's potentially disastrous. It will do more harm than good. So we're going to have to think this through further. Now, the scoping guide, has some interesting concepts, but it's not fully elaborated. It's a little bit more of a, a talking outline, than a thorough depiction. A particularly hard question is going to be, what about managed service providers who are so important to the ability of many companies to transition from the limitations of a premises system to something that's on cloud or in the cloud or cloud enabled. There are good reasons to want to know of the security of the MSPs. On the other hand, do we really require all MSPs to go through all CMMC? Where are the assessors to do that? What are the standards to do it? What is the cost and benefit? Are there other means of assurance, short of imposing the full cost upon the MSP? Questions to be answered, I think, that must be answered.
Well, and as an MSP who is fully committed to CMMC, I'm happy to see that requirement because it maybe cuts down the competition a little bit. But yeah, I think that it's not exactly clear what that standard should be, right? I mean, there are MSPs like ourselves that are committed to that,
right.
And there's others that have grown up in the commercial sector and definitely don't even have an eye on it. But they may be perfectly fine from a security perspective, but can they really?
But how do you show it? How do you show it?
Right. Exactly.
No, I mean, I know there are cloud service providers and MSPs who are totally committed to CMMC and probably are working to be sure they could pass a CMMC assessment. That's great.
Mm-hmm.
But one question is, are those the only people that you can look to for help? And what about the tool providers? We need to be thinking not just about the solutions which are best and most expensive, but I think, about incremental opportunities to improve your security as you move on a path over time to get to full compliance. And one of the things that CMMC 2.0 does essentially is to give us this interval between today and the formal effectiveness of the new rules. Could be 2 years away. We have this 2-year interval to kind of get our acts together and to improve everything so that we have high confidence that when an assessment comes, that you will pass. And the best way to have that high confidence is not only to take the measures that are indicated, but to have somebody who is perhaps an accredited C3PAO do an informal voluntary assessment so that you essentially have run through the whole set of traps with somebody who is accredited to assess, when the requirement applies. You've done it beforehand. That's one of the opportunities that I think are available to companies and that some may choose to use.
Agreed. Well, I think that we can spend probably another 30 minutes on the scoping guide. So I'm going to jump. We need to wrap things up because we're at the end of our time, but I do want to ask one more question about sort of the outcome of CMMC 2.0. Big shift in CMMC 2.0 is moving back to rely more on self-assessment, self-attestation. In your mind, does self-attestation and the move to this, does that increase risk for contractors? Based on earlier conversation about false claims and all that, if instead of getting a C3PAO opinion, we're going to rely on our own opinion, does that make the risk higher?
Well, maybe, but let's be realistic. If we talk about level 1, self-attestation now is going to include some kind of annual affirmation by a senior officer. And yes, there is some risk that that is done falsely, that it could expose you to a false claim. But there are hundreds of thousands of companies out there at level 1. And DoD's investigative resources, are finite. And the number of problems that could occur with a level 1 company that had consequence to merit false claims action is probably pretty small. So I would say that for individuals at companies who are doing those affirmations, those attestations and affirmations to increase their personal risk. And that was really the point. And if you're telling an officer that it's not just your company that could be in trouble by an affirmation, it's you, the person that signed it. Well, I can tell you from too many years of experience that company officers generally take those risks pretty seriously. Now, up at level 2, it's a little more complicated because we have this bifurcation concept. We have a high side where we're going to be dealing with information important to military programs and you will get assessed. And then you have a low side still at level 2 where you'll do a form of self-attestation and annual affirmation. Our biggest problem is we don't know where the line is or how it's going to be drawn or who's going to be above or who's going to be below, or whether you're below, you're going to be looking to do work that's above. I mean, this is a subject that really needs to be resolved. Yeah. I would certainly say that, the risk of non-compliance for companies on the high side of level 2, that is those who will be assessed, has definitely gone up. The risk of compliance to companies on the low side is probably abated, but there is still some risk because of that annual officer affirmation.
And that high side, low side, boundary may in fact be a dynamic slider that the DoD can move as they get more C3PAOs in the marketplace and they feel that it's reasonable to have more contractors undergo a third-party assessment. They could declare more programs to be critical, right?
Well, you're absolutely right. Look, I mean, a lot of the reason behind 2.0 was realism, reality, scaling, scope, and resources.
Yep.
The reason that level 1 people are not going to be assessed is they made the judgment as just don't have the resources, cost too much to get them, and put too much burden on those being assessed with too little benefit. And similarly, people have CUI, well, they're in level 2. The reason you have this bifurcated approach is, first, because they don't think they're going to have the resources to do everybody at level 2. I don't know the number of level 2. I've heard anything from 20 to 40,000, sometimes a few more. That's a lot of companies.
Yep.
So what they're saying is, well, we're going to do this on a risk-informed basis, and we care more about some information than we do some other information. And that CUI, which actually pertains to an important military program or defense capability, we care more about that than the stuff that doesn't. So we're going to initially require assessments of those who have the more important or more impactful forms of CUI, and we're going to defer assessments of the latter. I don't know whether the scale will slide or whether it'll just go down by reason of their including more companies in the group that need to be assessed. But I would say this: if you're already doing work on important defense programs of a character where the loss of your information might benefit an adversary, say China, you should assume that you're going to be on the high side and that you will be required to have an assessment and a certification. If you're doing work that is below that line, you have to ask yourself, what are my future business plans? Do I want to do work for DoD components or program offices? That's more sensitive, because if I'm looking to do that kind of work in 3 years, I'd better do the work to be prepared to be assessed. But I would say that anyone that is in level 2, high side or low side, should expect eventually that they may be assessed. And those who are on the lower side with benign or unimportant information, maybe they have a little more time to do it, but they should not ignore these responsibilities. They are now subject to 7012, 7019, and 7020. They are now expected to conform to the 110 requirements of 171.
Well, Bob, thank you very much. I appreciate your insights as always. Informative, thought-provoking. Thanks to you. Thanks to Wade Forbes, who's been sketchnoting this on the screen as well. We'll send that out to the audience after we wrap up. And thanks to all of you in the audience. Had some great questions come in. I couldn't get to all of them in the 30 minutes we had. So maybe we'll look at diving a little bit deeper into the scoping guide and some of that. And again, that just came out late last week. So it's fairly new. As we digest it, we'll have another session on it, I'm sure. So thanks, everyone. Please join us for future town hall meetings. Our next session will be Wednesday, December 15th at 1 p.m. Eastern. If you don't have the details in your inbox, please visit our website, neosystemscorp.com. Thank you very much.
Thank you.